How much would CNN have paid Nicholas Sandmann to avoid discovery in the Sandmann lawsuit? We may never know the answer, but one thing is for certain, avoiding discovery in a lawsuit has definitive monetary value. Viva Frei, Montreal litigator turned YouTuber. I do vlogs, and I often say in my videos that the aggregate knowledge of the internet is greater than any one individual. I say it because I mean it. In my most recent vlog explaining what to make of the settlement between CNN and Nicholas Sandmann, I discussed in great detail why a plaintiff might be inclined to settle with a defendant. I also explained in great detail how one can't really make all that much of a settlement unless they know the quantum of the settlement. A number of people in the comment section were saying, whoa, Viva, you sort of ignored the fact that CNN might have a vested interest to settle this lawsuit to avoid discovery. Now, this is in fact an issue that I've discussed a lot in previous vlogs, but I should have gone into it in the context of that video. In the context of litigation, oftentimes there is great value to avoid the discovery process. Now, for those of you who are fortunate enough to have never had any first-hand experience with the litigation process, something I've said time and time again is that litigation is a two-way street. When somebody makes the decision to sue another party, it's not a one-way street in that the plaintiff gets to do whatever they want, whenever they want, for however long they want. The plaintiff has rights, but so does the defendant. And for any plaintiff who thinks that litigation is in fact a one-way street, they are soon enough going to find themselves on the receiving end of depositions. Depositions, discoveries, examinations, the terminology differs by jurisdiction. It is the process through which the parties get to test the legitimacy of the claims of the others. It's the process through which the parties get to explore or discover the lawsuit by requesting a slew of information, documents, etc., etc. The discovery process has been described as the process through which one party gets to undress the other party, and that might be a bit of a graphic image, but it's quite accurate in terms of how discoveries feel. A party to a proceeding sits down in a room to be grilled endlessly by opposing counsel. If they are unlucky, they do the examination in a dingy, windowless courtroom, where they can sip on stale room temperature water in a dirty glass. Alright, I may be exaggerating for effect, but that is essentially what the deposition process is like. A party sits down, is grilled by opposing counsel who asks a slew of questions about the file, questions that are directly or indirectly related to the file, questions that are oftentimes invasive and uncomfortable to answer. Oh yes, and the testimony is always under oath, so the witness is permanently faced with the real prospect of perjury if they lie or give wrong answers. Depositions are not fun, period. Anybody who says they are fun probably enjoys going to the dentist. Now, this may be jurisdictionally dependent, but typically the defendant gets to depose before the plaintiff. If there's any benefit to being sued, it's that the defendant can say, I'd like to examine the plaintiff before the plaintiff examines the defendant. But other than that, there pretty much is no advantage or upshot to being sued. When a party gets sued, they know that sooner or later they will be deposed and the plaintiff will request a slew of documents and additional information from them. So now, bringing this back to the Nicholas Sandmann versus CNN lawsuit, what might have been CNN's incentive to settle the lawsuit? And the obvious answer would be that their incentive would be to avoid depositions for fear of what might be revealed during those depositions. Regardless of whether or not CNN gets to depose Nicholas Sandmann first, one knows that if the lawsuit continues, eventually Sandmann's attorneys will have a representative of CNN in a room, at which time they will be grilled on all of the facts directly and indirectly related to the lawsuit. A slew of documents, emails, internal correspondence will be requested of that CNN representative, and CNN knows that barring a settlement, they will one day have to undress themselves before the plaintiff.
Metaphorically speaking.
And who knows what would be revealed during that deposition and how damaging it would be to CNN's position in the lawsuit or CNN's business in general. Now, sure as sugar, you know darn well that unless CNN is being represented by incompetent attorneys, they have done an internal assessment of risk. Nobody should go into deposition unprepared or without having first done a risk assessment. It's not during or after the deposition when you see what has been requested that you assess the risk of communicating that documentation. And depending on the level of risk, that might influence one's decision to avoid a deposition by settling the file. So CNN undoubtedly had economic interest in settling the file to avoid the depositions, if only to avoid the costs of the depositions. Even if they had assessed their own risk and determined it to be minimal, there is still a serious cost to proceeding with examinations. You've got stenographer fees, lawyer fees, and then you've got the time that is going to be required in gathering the information, reviewing the information, and preparing the information for communication to the opposing party. And that's just the hard cost if your risk assessment was minimal. Let's assume that CNN knows they have very compromising internal correspondence that they never want to see the light of day. Barring a settlement, those documents will in fact see the light of day, so there is a monetary value to do what is required so that those documents don't see the light of day. And that quantum would factor into any amount CNN would agree to pay as a settlement. Reading through the comments on my vlog explaining the Sandmann settlement, which I will link right here in case you haven't seen it, a lot of people are placing a huge dollar figure on what they believe to be smoking gun internal correspondence correspondence, 50 million, 80 million, 100 million, 250 million, even more than Sandmann was asking for. And I've got to say, in my humble opinion, I think that that is unrealistically optimistic. Just play the thought experiment. What would be the most smoking gun of an internal correspondence that would sink CNN entirely? Let's just assume by some dream of dreams that there is an email from Jeff Zucker, chairman and president of CNN, to the effect, let's destroy this kid, Nicholas Sandmann. How much would that be worth? Apparently, the largest award for defamation to have ever come out of Kentucky was something in the order of $100,000. But even if we look at the Gibson's Bakery versus Oberlin decision, which was a monumental decision ordering something like $44 million in damages, $33 million in punitive damages. Incidentally, I did a live stream explaining that entire decision. I'll link it right here. Even if we take that case, which was an over-the-top case of libel, slander, tortious business interference, even in that case, after a full trial, they were awarded $44 million in damages, $33 million of which was punitive damages. The judge reduced the punitive damages to $25 million, and should Oberlin appeal, they could probably even reduce the punitive damages further. So all that to say, even in one of the most egregious cases in recent memory, and if you're not familiar with the Oberlin situation, read into it, it was egregious. The plaintiff after trial got $11 million in damages and $25 million in punitive damages. Now, imagination and optimism being an awesome combination, there seem to be a lot of people out there under the impression that there is some smoking gun in CNN's system that would be worth $50, $100, $200 million to settle so as not to be revealed. I don't happen to share that optimism, and my belief is that even if this were to have gone to trial and the smokingest of smoking guns were revealed, I don't think that a jury would have put a dollar value on it of $100 million or more. But this entire discussion now has made me think about what the discovery would have looked like. And I think it will be a fun and educational exercise to go through what I would do in order to prepare for any deposition with CNN, Washington Post, NBC Universal, how I would prepare for and conduct that examination to get the information that we want. So let's do that in the first installment of Preparing for a Deposition. It does no good entering a deposition with no fixed goal or objective, just meandering around thinking I'm going to ask some questions and hope something good comes up. You need to have a purpose, a direction, and a goal, otherwise you will be lost, much like life. So if I'm Sandmann's attorney and I'm heading into a deposition with CNN, what are my objectives? And this illustrates the wonderful interplay between objectives and knowledge. If you don't have a proper understanding of the law, you will not be able to have proper objectives in the deposition. So bearing in mind that we are in the hypothetical deposition in the context of a lawsuit in defamation, we need to understand at the very least the basics of defamation. What do you need to prove? The publication of a statement, the falseness of the statement that was published, and the damages to the plaintiff resulting from the publication of that false statement. I think I might be missing one criteria, but you get the idea. But that is only part of what you need to know in order to know what you need to get. Is the plaintiff a private citizen or public figure? And why is this relevant? Well, the standard for defamation is different for a private citizen versus a public figure. If the plaintiff is a public figure, then you have an additional criteria that must be met in order for there to be defamation, and that criteria is actual malice. New York Times Company versus Sullivan, 1964, Supreme Court of the United States. In virtue of that landmark Supreme Court decision, when the plaintiff is a public figure, the statements that were made need to have been made with actual malice to qualify as defamation. Now, in the Nicholas Sandmann defamation lawsuit, unless it gets to court, there is going to be the unresolved question as to whether or not Sandmann qualifies as a private citizen or a public figure. There's going to be the question as to whether or not Nicholas Sandmann qualifies as a limited purpose public figure. And that is to say, a private citizen that is deemed to be a public figure because they were thrust into the spotlight on a specific issue. These questions may never get answered, but these are always the question the examining attorney is going to have in mind in order to know where to go with the examination of CNN, Washington Post, or NBC Universal. To be sure to respond to the defense that you know is coming to the effect that Nicholas Sandmann is a public figure or limited purpose public figure, the line of questioning you're going to want to get out is going to have to get at the actual malice aspect of the defamation. And so you know that your ultimate goal of any deposition, just to be sure, would be to find any smoking gun to illustrate the actual malice behind the conduct. You can take your chances and just try to find the elements of defamation in the hopes that the court recognizes that Sandmann was in fact a private citizen. But if the court or jury determines that Nicholas Sandmann was a public figure or a limited purpose public figure, then you need to have found the evidence of actual malice. And to make evidence of your actual malice, you can have the smoking gun of an email saying, destroy this kid at all costs, or you could have the deliberate not following internal protocol just because the story was too good. And so bearing these objectives in mind, this is where the line of questioning would go. You would have your first tier of questioning as to what the protocol or the journalistic standards are within CNN. In general, what is the protocol for verifying or fact-checking videos that appear here on Twitter? What is the standard of rigor that journalists are required to engage in before publishing a news article? You would request communication of all internal guidelines, directives, protocols as relates to journalistic standards. You might ask for communication of any keynote presentations that are given to the journalists. Any instructions as relates to how journalists are supposed to conduct themselves when reporting. And you would do this generally to establish whether or not there is any internal protocol as relates to journalistic ethics. And here it's going to be one of two outcomes. Either there is an adequate protocol or there isn't an adequate protocol. If there isn't an adequate protocol, that is going to be good for your case. If there is an adequate protocol, then the next line of questioning is going to be whether or not CNN followed the protocol as relates to the Sandmann story. And then here you would want to ask for any correspondence between the journalist and the editors as relates to the specific Nicholas Sandmann publications. Was there any discussion as to sources? Was there any vetting of the sources? Was there any internal disagreement as to whether or not the story was strong enough to run with? And here you could easily imagine why CNN might want to avoid all of this discussion to begin with. They either have protocol or they don't. If they have protocol, it is either good or it sucks. If it's terrible, it will affect CNN as a brand to anybody who places any value in CNN as a brand. If it's terrible, it might satisfy the criteria of actual malice as relates to Nicholas Sandmann to the extent that he is deemed to be a public figure. If the protocol is actually good, but CNN just didn't follow it when it came to the Nicholas Sandmann story, that can also help support the theory of actual malice. And if the protocol is in fact good, people were aware that the protocol was not being followed, they voiced concerns internally, well, that can be very, very relevant. And even more relevant than that, if internal correspondence confirmed an actual plan and strategy in all of this, well, you can understand why CNN might want to avoid a deposition at all costs. And this is how one would have to structure the deposition. You would want to establish general internal protocol. You would then want to assess whether or not that internal protocol was actually followed with Sandmann. And you would want to see any and all correspondence, external and internal, as relates to the Nicholas Sandmann story and the follow-ups and the publication, etc., etc. You would gather all of that information, assess it, and then craft your file accordingly. Going into an examination like this, you don't need to have a list of 500 questions. Oftentimes that will do more harm than good. You need to have your objectives, you need to know where you want to go, and you need to be able to go with the flow of the deposition. Sometimes the deposition will lead you to magical places, but if you are stuck following your line of 300 questions, you will not notice that's where it's going. General to the specific, bringing it back to your case. All right, all that to say, I don't think the attorneys in this file need any advice from me. I just thought that maybe the general public would appreciate this exercise. And while I have no doubt that there would be very compromising correspondence out there, I doubt very much there would be a $100 million smoking gun of an email. Like Tom Cruise said in Minority Report, you know how often you have an orgy of evidence? Never. But there would have undoubtedly been things revealed in deposition that CNN might not want to become public. It's just going to be up to each and every one of your personal assessment as to what you think the dollar figure on that would be. And with that said, if you want to see a humorous cross-examination gone wrong, that is to say me cross-examining my youngest kid, I'll link that video right here. If you want to support the channel, consider buying some merch. There is a support link in the pinned comment, and now you know you vlog. Peace out. Booyah.